welcome to you guys. We're going to start right on time here in a minute. In the meantime, please, we are going to use the chat liberally in this conversation. So please go to the right and use the chat. I'm Mike Whelan. I am the Chief Community Officer at Law Insider. I am here with my friend Marcia Narine Weldon. She's going to be presenting on intellectual property in MSAs. That's what this conversation is about. I'm going to give you a little bit of background on this conversation, a little bit about the tech tools and how we're going to use it, and then we'll get rolling. In the meantime, please, just to repeat myself, go to the chat and let us know where in the world you're from. I want to see that you know where the chat button is, because we are going to use that to interact with Marcia. Marcia is a professor. She likes to talk to the students. So just a couple of notes in this conversation about IP and MSAs. I'm going to give you a couple of caveats to be fully transparent about what we're doing here, so you know that this is a conversation for you. So number one, if you are a law professor in IP and you wrote the book on IP and MSAs, we are not breaking any news here. This is not going to be, the ultimate guide to. This is introduction to these kinds of topics. We are going to try to push you toward the questions that you should be asking in these kinds of agreements with these kinds of issues. But we are not pretending in this 50 minutes that we have in this conversation that we're going to be able to deep dive into all of it. The second thing is I want to be fully transparent about what we're doing here. We have a course in the Law Insider Premium Library that is called In-House Orientation that Marcia teaches. And we are trying to get you all ready for that, because some of you, that's going to be useful to you. That course is going to be useful to you. It's going to be applicable. The moment that we're trying to capture is if you're new to a role, whether it's in-house or you're a new attorney, you've got a new client, there's some newness that is making you feel like, I need to know what to care about. I feel a sense of overwhelm. I feel a sense of fatigue. I feel a little insecure. The purpose of this course is to orient you so that you feel confident. And the way we do that is by teaching you to lean into your competence to do the job really well. So we're going to talk about that course later. But in the meantime, we're using this webinar as an opportunity to, with Marcia, show you the mental frameworks that you need to use to be successful in your job. We think competence is the path to confidence. And so we're going to talk about that. All right. With that said, just real quickly, I see that a bunch of people are in the chats. I did get a question from somebody. Is the audio working? My audio is working, so let me know if yours is not, but it sounds like people can hear us and see us. So the chat is one feature. We are going to be we're going to be showing examples from the Law Insider database of language in MSAs that deal with intellectual property. So we are going to ask you to go into the chat and interact with us. We're going to ask your opinions, your thoughts, what you think should change about these. So use the chat, talk to each other, debate things over in the chat window. The other thing I'm going to ask you to use is the Q&A feature. Now, realistically, we're probably not going to be able to get to very many questions during this conversation, but that doesn't mean that those questions are not valuable. I would love to see, as the Chief Community Officer, what else you want to learn about. What are you missing? What don't you know that you feel like this didn't cover, you want to dig deeper into? We can have future webinars, workshops, courses, ebooks, contract teardown episodes, whatever is helpful to you. Go ahead and ask questions, even if we cannot get to them. And also, if you'll go look at other people's questions and thumb up the questions that you also have, so that I can see, hey, 18 people really want to learn about this one thing. Use those features liberally, because that will help a lot. All right. Final thing with the technology, before I hand it over to Marcia to run through the agenda with us, I'm going to ask Dory to put up a poll. This poll is going to help us understand who's in the room. So please fill out this poll real quick. We'll give you just a few seconds to do that. It'll help Marcia to know how to target this conversation. So please go respond to that poll. We'll give you a second.
So Mike, while they're doing that, you have a couple of questions that in the Q&A that you might want to answer so that people don't continue to ask them. One is about whether the slides will be available, and the other is about CLE. So I figured you might want to cover that while people are voting.
Very good. Short answer is no to the CLE. I could tell you a whole story about the difficulties of getting CLE across several states. There's a world in which we figure that out eventually, but it has been quite hard to figure out and operationalize so far. If you have self-study credit in your state, please email. Most states do this. Please email me. It's just mike@lawinsider.com, and I will cooperate with your state to try to get that CLE for the self-study credit. For the the other question, which was about the slides, yes, we will be delivering slides. We'll send a follow-up email that'll have the recording of the webinar, that'll have the slides, and that'll have the information about the course. All right, Dory, can you go ahead and close that poll for us? All right, so real quickly, Marcia, it looks like 43% in-house, 11% solo, some small firm, big law, 25% legal ops. So about 43% in-house, about 25% legal ops. So quite a few people who are in corporate environments, and then the rest, I assume, are trying to serve those environments. So that is our background. With that, I'm going to turn time over to Marcia. Before I do that, I just want to say something about Marcia to orient the rest of you. Marcia is practical smart. And by that, I mean, yes, she is a professor, but she is also a veteran of in-house. And specifically, she is the director of the Transactional Skills Program. And I'm underlining on purpose, transactional and skills. So we love having her on because she gives these this practical counsel. So Marcia, with that, I'm going to turn it over to you to share the agenda and get you rolling.
So I'm going to share the agenda. Nice to see all of you guys chiming in from all over the world. And for those of you in Miami, look me up on LinkedIn. Let's get together. But the goal for this is we're not going to answer every question. As a matter of fact, you might leave with more questions than you start with, especially those of you that deal with MSAs all the time. Because the goal for this is for you to leave and say, I never thought about that. Now I've got to think about that. Who do I need to call? Whenever I listen to webinars, I always want to leave with some action items. And that's what I want to leave you with as well. So I'm a professor, but I'm also the general counsel of a startup. The third one I'm the general counsel of. I spent many years in-house, 12 years in-house. And I come from big law and small law. And so when I think about these things that I'm going to talk about today, and we'll talk a little bit more about the course later, it's what are the kinds of things that you need to go to talk to your operations people, your internal stakeholders, maybe your CISO if you have one, or you might be the only person. And you have to think about how do I practically put some of these things into place. So we're going to ask you, not just because I'm a professor, but because you learn by doing, we're going to show you some clauses, and we're going to ask you to say what you think is good about these clauses or what's not so good about the clauses. And you may come up with things that we didn't come up with, and that's perfectly fine. So we're going to be focusing on a few types of things, the types of IP and their different agreements, what happens when you're using pre-existing IP, what are the key reps and warranties you want to have, indemnification, confidentiality, and a preview of the course, which is what Mike is going to do. Anything that I left out?
No, I don't think so. I think that's it. So just again, to reiterate, because we got some people coming in later, please use the chat to discuss with each other. Please use the Q&A to signal to me that you've got questions. I may be able to interrupt Marcia if it's relevant to the outline that we have, but still those are useful. We will have the recording. We will send out slides. Marcia, take it away.
All right. So since many of you use MSAs all the time, but some of you just sometimes, what are we thinking about this? Why do we even use these? Think about the fact that you don't want to have to worry about redoing and negotiating the key terms of an agreement when you have an ongoing agreement or future situation. Now, the biggest thing for those of you that are very experienced that you know that you deal with is scope creep, right? You have an MSA, you might have your statements of work, but things go outside of the box. What we're going to focus on today is not the issue of scope creep or those kinds of things, but we're going to focus on the IP issues specifically. So you, of course, know you'll have your pricing models, you'll have your dispute resolution, ownership rights, etc. And that's what we're going to be focusing on, really the ownership rights. Who owns what? So you might not have heard of the terms this way, but we're talking about types of IP. We're not just talking about copyright, trademark, patent, trade secrets. We're also talking about the kinds of IP that might come in. And a lot of times I see lawyers and clients and others just cut and paste from agreements, right? So they're just cutting and pasting from an agreement that worked before. But it's really important when you're starting off, and even if you're very experienced, I want you to think about what type of IP is there actually involved, right? So you have your background IP. This is what either the service provider or the customer already owned, right? Then you have your foreground. This is what's created within the agreement. And you don't have to use these terms. So if you say, wait a minute, I've never seen these terms before, this is just a framework to think about it. So if the word foreground is not in your contract, I don't want you to freak out, right? Then you have the side ground. This is when one of the business partners creates some IP that is outside of the agreement, but it could be somewhat relevant. And then post-ground, and this is particularly important. What happens to the IP after the agreement is done, but maybe there might be some modifications and improvements? Who owns that? What are the rights? So we'll think about that as well. And it's a common misconception that, IP ownership defaults to the client, and service providers will clearly have some valid rights for certain kind of IP issues. So it's really important that we understand the nuances of IP assignment and find a balanced approach that protects both parties' interests. And I think if I look at the poll, we have more service providers than we do actual customers, if I'm not mistaken, which might tilt the conversation a little bit. So we're going to go straight ahead, right? Again, it seems like we have a lot of people very experienced in MSAs, but I don't know that you've really started thinking about what's the type of core IP you need to protect. And we're doing some background, and we're going to go straight into some clauses. I think we're looking at 5 different clauses in a few minutes, right? So what is your core IP? Do you know, and could you actually tell somebody what's the specific IP that you're trying to protect in the negotiation? Think about the licensing. How flexible do you want to be? Instead of transferring ownership, is it better to license the IP? And then if you're doing that, if you're transferring ownership, how are you valuing it? And is the valuation that you as the contract lawyer, the procurement person, is that the same as what the business actually thinks? Right? And you want to clearly define the scope of use because you want to prevent the misusage while still having some flexibility. So what are the biggest pitfalls we see? Right? And I look at contracts all the time, and some of them done by the biggest firms in the world. And you still often will find, again, because of the cutting and pasting, and now because of people using AI to put the contracts together, sometimes you're not really clearly saying what your IP is. And this is going to lead to disputes. You might have some kind of overreach, right? So providers, a lot of times inadvertently agree to transfer rights to background IP that's essential to their business. It's not just the IP that's created for the clients. You want to be careful about that. A lot of times you ignore the pre-existing IP. So you've got to make sure that you're excluding pre-existing and third-party IP from the transfer if that's what you want to do, because if you don't, you're going to lead to claims of infringement. And a lot of times there's no provisions for improvement. Okay, so sometimes you fail to address the ownership of improvements to the IP. Maybe this is made by the client, or maybe it's made by the provider post-agreement. So who owns that? And what rights exist there? So now we're going to go for our first example, and now we're having some class participation, right? I want you now to sit there and look at this slide, and I want you to type in the chat what you think of this clause. Is this a good clause? Is this not so good clause? What are the problems that you see? And I really want to see some participation. Otherwise, okay, I'm looking at the chat, I'm just going to start calling out people like a professor. So I'd really love you guys to put something in there. Take a look. Okay, we can't just have not good. Now you sound like my students. That doesn't look good. Let's be a little more specific. Standard but aggressive, vague, too broad, dangerous, not detailed enough. Too one-sided. Okay, very broad, one-sided. I like it. Okay, so somebody says I like it. Great. So let's go on and let's kind of think about some of the things that I thought of. Right? So one of the issues I see, there's a lack of specificity, right? So we don't really know. And let me see if you guys have that. I think you're on the wrong, not in the same slide that I'm on. Let me see. Okay. You still see the problem, correct? With the highlight yellow? Okay. Right. It doesn't clearly distinguish between IP directly related to this project and the IP that the contractor or the service provider might develop independently, but concurrently. And it lacks a specificity of the types of IP, which could lead to broader problems, right? You've also got stuff about automatic transfer. And the automatic transfer of ownership, that's a problem because you might have to have some written assignments required. And it ignores pre-existing IP. It doesn't exist the pre-existing IP or the use of third-party IP, which is a theme you're going to hear over and over again when we talk. And that could be essential to the project, but the contractor or the service provider might not own it. Anything else you guys see in there, please put it in.
Marcia, let me ask, I want to ask, in terms of, there was somebody, Aaron, who asked, mentioned you have to define the IP ahead of this part of the contract. Mary said exactly. With the idea with this, if we're going to create those categories of IP, that we might put them in a definition section, and then this is a capitalized term, because
Absolutely,
this
you're
is
going to have them
defined.
as defined terms, and you want to be really clear about what your IP is. And that's why even before you do this, and again, even if you're super experienced, you want to make sure you're really clear about saying, what's the core IP for this document? Because you might have your specific definition of IP, and then you cut and paste it in here, and you're missing something important, right? So you need to have your own kind of IP audit internally before you deal with the other side, whether the service provider or the customer. What do we actually need for this? What's ancillary? How do we value it, etc. Right? And again, Karen has something great. It can conflict with other customer contracts, all IP related to the customer's business, right? Okay, so these were some of the problems. You guys are going to get the slides, but I just wanted to kind of add in some of the things that we thought about. So here's another way. This one has green because it's a little bit better. What do we think is good about it? And again, why am I making you guys do this? Not because I'm lazy, but because you learn by doing. And we all do a much better job of poking holes in other people's writing than we do our own. So, and as you're looking at this, it's really important to realize that this all comes from Law Insider's database, which comes from SEC file documents, which are done by typically public companies with really expensive lawyers. Okay, so lest we think that these are some random lawyers that put this together. So if the one that wasn't so good looks like yours, don't feel bad. Someone paid a lot of money for that contract that you guys just tore apart. Okay.
Yeah, I love the people in the comments who are still beating this one up, who are still coming at the green example. I love it.
So we just put better, right? This is a little bit better. It's good and narrow. Maybe you define internal business profits, remove perpetual. So there's a whole concept of in perpetuity. Do you want that? And again, I see somebody saying, if you're the service provider, you might think this. That's also really important. It depends on who you represent. A contract term is in the eye of the beholder. Okay. So here's another one. What do we think about this one? This one's slightly different. Who's responsible for third-party IP? Broader IP scope. Okay, seems better than the prior two, right? Okay. And again, depending on who you are, you're going to care about certain things. But one thing that this does well is it talks about pre-existing IP. You need more defined terms.
Yeah, I love the multiple people in here saying third-party IP here. Again, lowercase, presumably not defined. That needs to be defined. We're going to talk about that in another section, but that's a really good point, defining these buckets. Yeah.
Absolutely. And who are the third parties, right? Who is the universe of third parties? Who are the universe of the people that are going to be involved in this agreement? Your representatives, your affiliates, your subsidiaries, your contractors, your employees. You want to make sure that all of those are really clearly defined, right? Who determines necessary? What about if it's, intended use? And this is why a strong definition section is particularly important. And that might be the subject of a whole other contract teardown webinar, right? So what's better, I didn't say it was perfect, is you have a clear demarcation between the different types of IP. It specifies the transferred rights, right? And defines the scope of the rights. So when we're thinking about this, we always want to make sure that we are being very transparent about the existing deals. And this is the third party issue we're talking about, right? Because we could have some problems. What's going to happen in the case of third party infringement? We're going to focus on that in a few minutes, right? Your intended use, should that be defined? Absolutely. Who's going to obtain the third party license if applicable? All of those things. You guys are asking great questions that these clauses don't necessarily address. And this is what I want you guys to be thinking about. And this is why we have you typing these things in, because if you're just listening to me lecture, you're not going to pay attention. But if you're pointing it out, and this is the same kind of analysis you should be doing when you get a contract, by the way, because remember, these are publicly filed documents. Okay, so what about the existing deals that are going on? Because if you're using pre-existing or third-party IP, you've got to be transparent. You've got to think about what are the rights, what are the scopes of the permissions that you have? And you want to ask, do you have the authority to use this in our project, right? And what about compliance with existing deals? Who has the responsibility to comply with whatever those license or assignments are? Okay. And I see the question LaDonna has, or LaDonna, I'm sorry if I'm pronouncing it wrong. Who's going to obtain the third-party licenses if applicable? You have to agree to that. You have to have those kinds of conversations, because otherwise, if it's the service provider that's providing this third-party IP to use in your project, if I'm the customer, I assume you've already got all that done. But I can't make that assumption. I have to ask the questions. I have to trust but verify, right? That's what we talked about auditing. Show us the proof that you've got that. It might be a little bit awkward, but what's more awkward is trying to figure out who's going to pay for the big legal fees later on when we're talking about indemnification. Okay. What considerations might you also think about? How many of you guys have heard of a concept of a tail period? Just type yes or no, or Y or N. Okay. So we have a bunch of yeses and a bunch of no's, right? A tail period is when the customer has maybe a 1 year or a particular period of time after the project completes, when the service provider has to assign any relevant patent applications, right? So you may be thinking about, you may be transitioning to another vendor, but also there could be a situation where the IP is so good that there might be some other rights that come from it. Well, who's got to do that? And does a service provider need to assign that? You want to think about that. Are there going to be any patent applications? So does this include patents related to the customer's trade secrets or any statements of work? And how many of you guys use a power of attorney issue, right? How many of you guys say if the service provider's signature is not available, the customer can sign IP assignment documents on behalf of the service provider? If you guys use something like that, type a Y. If you don't, say no. If you don't know, say DNK. Okay. How many of you guys think about reusing the deliverables? So how do you ensure that the deliverables can be reused across different projects? If the service provider, if this IP is, or these deliverables are critical to the service provider's business model, is that in your contract that you can do that? So Evan says, I've never seen an MSA with a power of attorney provision for IP rights, right? So that's what you might want to think about. So I like how we're seeing some say yes all the time. Some say, I've never seen that before. And that's the purpose of this webinar, right? To get you to say, let me go ask my colleagues about this. And you might say, I'm never going to sign it, but you might say, I never thought about this, because what if the service provider doesn't want to sign things over later? This is why you want to do this. The whole point of an MSA is because you're trying to prevent future disputes in ongoing situations. And then think about if you're the service provider, which looks like we have a lot of them here, right? The service provider might need to include its own pre-existing proprietary content in the deliverables, and they might want to retain the rights to that. So again, it's really important that you know, what are we doing for this project? What are we doing outside this project? What are we doing for future projects? What do you want to share and what do we not want to? And yes, a lot of people, Risa, are going to push on that clause. And yes, copyright IP is, of course, is critical. We're talking about patent here, but it could be copyright, trademark, anything else, any kind of protection that you're going to get for your intellectual property. You want to make sure that after the contract is done, that you have sat there and thought about this. Okay. Another example. Time for you to tear it apart. Time for you to be like Mike's guest on Contract Teardown. All right. This shouldn't take very long. It's just one sentence. What do you think about it? Lynn says, wow. I don't know if that's wow and amazement, or wow, a company actually filed that with the SEC. I don't know.
Yeah, I think we could all agree this is too short. So let me specifically, what's missing? What do you not see?
Yes, please put a little bit of what we think is wrong with this. Right? There's no mention of disclosure, licensing terms. What do you mean by as needed? No protection against infringement risks. The permissions are vague. This language is overly broad. A lot of you guys notice that, and vague. It doesn't specify the conditions under which the third party can be used, IP can be used, what the responsibilities are, who's got to obtain the license, who's got to maintain the license, who's responsible for paying for the licenses. So you're going to have disputes, especially if there's any costs or issues from unauthorized legal use. And remember, what do we know? Companies hate to go to litigation. Nobody wants to go to litigation because you didn't put the right clause in there, and some court is going to have to sit there and determine this. There's also no reference to compliance. It doesn't address compliance to the third party's IP terms. And so that can make things very, very difficult for you. right? And there might be specific considerations that it could impact and expose your client, if you're the customer, could expose the customer to liability, right? So I think most of you guys seem to get most of these issues. And again, the shorter the term, the easier it is to beat it up, right? So this is just a listing, because you guys are going to get the slides later, of some of the things that I just mentioned, in case you guys weren't typing very quickly. But these are some problems, and there are many, many more. Now let's look at another one. I'd like you to tell me this one is better. What do we think is better about this, and what's still missing? And I'm going to give you guys about a minute or so to take a look. Okay, somebody says, I hate the indemnity provision in here. And someone says, oh, there's an indemnity provision in here. I feel like we should have had you guys rename yourself by like vendor and customer. It'd be really interesting to see the perspective. Okay. So you guys are saying what you don't like. Let's talk about if there's anything that's better here. And we are doing a whole separate section on indemnity, by the way. So keep in mind that often indemnity is going to be a separate clause. Right? And they're having a field day. So let's talk about what's better than this one, about this one. Not great, but it's better. Oh, I don't have that. I'm actually going to talk about best practices. Sorry. As you guys are kind of continuing to go through all of the issues that you hate about it. Oh, I see one of my students on here, Carol. Nice to see you, Carol. All right. Let's think about some best practices when you're incorporating existing IP. First of all, again, thinking about, are we going to license it or assign it? And if assigning, how are we going to focus on the value of it, right? Scope of use, which is something you guys were talking about a lot. What's the scope of use in terms of not just the pre-existing IP, but the duration, the limitation? What about geographical or territorial restrictions? Think about segregating your IP rights. So ensure that the agreement clearly distinguishes between the rights granted for pre-existing IP and IP developed during the project. You want to have IP audits. I know this is awkward. Everybody has these things in their contracts, but nobody wants to do it, right? You're going to think about what's the audit on the IP to ensure it doesn't infringe on the third-party rights before you're incorporating into the projects, because you don't want to, we're going to talk about indemnification, but we don't want to have to get to indemnification. So if you do things right on the front end, you don't have to worry about, let's go see what the indemnification clause says. You're going to talk about doing indemnity clauses that specifically addresses third party, and then you have to develop some kind of regular monitoring and compliance issues. So think about how you might systematize that. So someone says, so the IP audit would be under an NDA before going to contract. You could do that. It could be or it could be, some of you guys might be doing kind of an MOU or something like that, where you start thinking about it, but at least ask the questions. What's the IP that we're putting in there? Where did you get it from? Do you have the license to the assignment? Are they transferable, right? Who has the rights to it? Because you don't want some third party now saying, I'm glad Whelan Inc. developed this new thing. I own part of that, because that's what we have to worry about. And again, even if you can use indemnification, we don't want to have to get to that. Indemnification is a risk allocation mechanism, but you don't want to have to try to get to that. So you want to deal with these issues well beforehand. Let's talk about some reps and warranties. And so Eden says this is applicable to other kinds of agreements other than MSAs. I think anytime you're dealing with anybody's intellectual property rights, or somebody is doing something for you, you know, if you're dealing with a SaaS agreement, a software as a service agreement, when somebody is using some kind of intellectual property to develop something for you, a good or a service for you, you always want to find out, where does that IP come from and who owns it and what are the rights to it before, during, and afterwards. What if one party can't disclose all pre-existing IP, do an NEA? That's important. That's why you have to actually ask those questions about, because, and this is especially important for service providers who might say, well, I can't tell you all the things that I have or where everything came from, because And that's, again, part of the negotiation. A lot of times I'm going to go to Dory Inc. because she's the best service provider. And I'm not going to ask these questions because he's the big dog in the field. But you have to ask these questions, especially if you don't have a good indemnification clause, because then you're going to be on the hook for it. When we're talking about assigning, basically assigning the ownership to you, you have it, right? Licensing is, I might license it to you. And if it's not an exclusive license, I might license it to somebody else. And this is A. Sagaya Selvi. And I hope I'm reading that properly because I have this big spotlight in my face for the lighting. And I feel like I'm like under a prisoner lamp. So it's really hard to see some of your questions. Sorry about that. And so you're thinking about the exclusivity of the ownership of the IP. So let's talk about reps and warranties, right? See these in almost every contract.
Marcia, I want to interrupt you just real quick. Because I got an interesting question from Eden Kravitz. Is this applicable to other kind of agreements other than MSAs? I wonder, just to reorient us, we've talked about a lot of sort of best practices with kinds of these things, but reorient us to the conversation about MSAs. I think because we're dealing with these long-term relationships that this is special. What about this is special? Where are you? Maybe mention that as we go.
I think you'll deal with it other areas as well, but because, like I said, if you have a SaaS agreement, a software as a service agreement, you have other kinds of agreement where some service provider is doing something that's going to involve intellectual property, you always have to ask these questions, right? I would even ask it in a basic independent contractor agreement, right? That the MSA, remember, this is, we're thinking there's going to be a continuing relationship, there's going to be future projects, and this is the master agreement that's going to govern everything else. We might have some statements of work, we might have other kinds of things, but this is the master agreement. But even if it's a one-off independent contractor agreement, the issue of IP is sometimes the most valuable thing that a company owns, right? And there's a monetary value to that. And so you don't want to take the chance of giving away what you're not supposed to give away, what you don't have the right to give away, or what you haven't adequately thought about in terms of the value of it. So hopefully that answers that somewhat. We're now going to go on to reps and warranties. So what are the basics? You want to have, thinking about ownership and right to use, right? Non-infringement, disclosure, and the rights to sublicense. So we're going to start to look at a clause. Here's a clause. Take it away. I think you guys have fun doing this. I guarantee you that somebody on this webinar, of all the people that registered and who are going to watch it later, have this exact clause in there.
I was waiting for you to say somebody in here probably wrote this.
Yes, all of these clauses. Somebody
or copy pasted it somewhere.
Right, yeah. But right now you feel like, oh, this is great. Like peer review. Deliverable should be a defined term, absolutely. And if it was a defined term, this would be a capital D. What does original work mean, right? It's far too vague. Again, the shorter the sentence, even though we don't want like long walls of words, sometimes we need a little bit more here, right? Is there anybody who's a service provider who's willing to say that they have language like this and why this is a good idea? Probably not, never mind. Pretty sure. Not going to happen. Definitions, right? So we know that service provider is a defined term because it's got a capital S, capital P, but we assume deliverable should be capital D as well, right? Okay, so he says, is there any good argument for the supplier to reject the customer's requirements to have warranties and reps, especially in the MSA? There's indemnification clause. So remember, your reps are basically a statement of fact that's true now or in the past. It's intended to induce reliance. That sounds very law professory, right? It'd be, I would not have signed this contract with you if I didn't know you were able to do this or that you had this in place, right? Right. And the warranty is that, okay, if it goes wrong, just like your warranty for your refrigerator, I'm going to make you whole. I'm going to pay for this, right? The indemnification is more like a risk allocation. And you're thinking about, and we're going to get to it in a minute, so I'm not going to spend too much time, but when we're thinking about the indemnification, we're thinking, who's got the ability to bear that risk? Who's most likely to screw up? I'm going to put it colloquially, like I talk to my students, and who can bear it. But let's look at how we might make this a little bit better. Because some of the problems with this was, right, too narrow. It lacks detail. It only covers the originality of the work. It doesn't cover things like non-infringement of third-party rights. It doesn't address whether parts of the deliverables could incorporate or depend on pre-existing works or other third-party elements. And that's really common in a creative or technical project. So let's look at this one, which is better, although you guys haven't liked any of the better ones, but that's okay, because I think we've now primed you to look for everything that's wrong. Let's think about also what might be better. So take a look at this. What do you still think is an issue, but what's better about this? And gold star for somebody who comes up with something positive. All right, Michael, thank you. So she's like, I still wouldn't do this. That's all right. Ashley's like, much better. I don't know why, but it's better. And by the way, it's not better because it's longer, right? So it's right. We've got the third party issue, right? That's important. And that is going to be a consistent theme if you get nothing else, right? So Rebecca's like, I can't agree on the third party, but it's much better, right? Again, next time you're doing these things, Mike, I think you need to have, Karen, supplier, and Jason, customer, because it's really important to think about the perspectives, because when you're looking at the contract, especially if you're outside counsel, right? Sometimes you're going to represent customers and sometimes you're going to represent suppliers. And you can't just take your same contract because no contract is ever neutral. We still don't know what the original works are. You're completely right, Sharon, right? So let's talk about what might be a little bit better here and best practices, right? We've got to talk about the ownership and the right to use, right? You want to have a warranty. So as you're looking at drafting, as you're looking at these clauses again, if you watch this over again or you get the slides, you want to have a warranty that the service provider owns or has the legal right to use the IP related to the deliverables and the services that are provided. Obviously, you want to have, this is why you have to have a rep and not just indemnification. Something about non-infringement, right? A rep and a warranty that the deliverables and the services do not and will not infringe on the IP rights of third parties. What's the limitations? Are there any limitations on the use? Maybe there's geographic or usage limitations. That's got to be in there. If that service provider has the right to sublicense it, or maybe even the customer, depending on how collaboratively you're working on this project, you want to put in there a representation that the client is entitled to sublicense the IP to the extent necessary for their business operations. Don't forget about due diligence. Wendy is multitasking. She's in the wrong chat. She says, sorry, wrong chat. Okay, that's all right. Okay, right to sublicense. We've talked about that. Due diligence. How are you going to perform your due diligence on all your service providers to verify their IP ownership and rights? Yes, it's awkward, but it's more awkward when you're involved in litigation. Indemnification clauses, which we're going to get to shortly. You have to include indemnification to cover the potential IP infringement so that the service provider is going to compensate. And then again, regular IP audits. You also have to have things like policies and training. Now, we all know some companies don't do any training. Some companies have training that people just kind of click and step through the box, right? They kind of go away, they do something else. You might want to think about specifically for these, for your MSA, is there some kind of training or policy or memo for the people that are involved in dealing with the MSA that they realize and understand what the obligations are? And it's time for a commercial break.
Yeah, I'm curious. I want to put a pin in something, Marcia, that you and I talked about before this, that was asking the questions about how AI changes all of this stuff, which is big questions. But I do want to point out that we're having this conversation in part because we know what it is. Marcia definitely knows what it is to move into a role and to feel that sense of overwhelm. You got to, man, when you're in a new job, like you don't know where the coffee machine is, much less how to make everybody happy inside the company. And I asked Marcia to put a course together to kind of help people get into these new roles. And something that I did not plan that Marcia did that was so interesting to me was that she answered that question by talking about some key contracts. And that is so fascinating to me that she said, look, you're here for a job. If you want to make people happy, go do the job. You can do all the other frill stuff too, like be nice to people and have good conversations and document things by you.
But okay.
But it is great to nail down these competencies to create the confidence that you need in the job. And so Marcia helped us create this in-house orientation course. It covers these 5 key documents. She also gives background on, being new in these roles and how to deal with the stakeholders in the company. But I think it's really great that we cover these key contracts. We also have inside this course worksheets, templates, guides that will allow you to not only hear the kind of stuff that we're talking about today to get your mind right, to get you asking the right questions, questions, but actually to help you through the process of answering them. So we have a link there. Dory is going to add to the chat a discount code that you'll be able to use at that link. So if you go, again, we'll share both the link and the discount code. If you're interested in this course, it is not for everybody. Some of you are way too far along in your process for this to be.
Stop you there. Let's stop you there, Mike, because
Yeah.
I was thinking about this as I was driving in. So when we were filming this, I had just taken on, and I've been practicing now for 32 years. Okay, so I'm pretty experienced. But I took on a fractional GC job for a medical device company that was under investigation. I had never dealt with some of these kinds of contracts. And I was thinking, I know contracts, but I don't know this stuff. I don't know this area. And so I think of the people that are in small firms, and I think of others that it doesn't matter how far you along you are, you really want to think about what are the key things? So employment documents is not, I didn't say employment contracts. I'm talking about the mistakes. I've been an employment lawyer for 30 years too. All the mistakes that I see that cost your company money, hundreds of thousands of dollars just to win a case, because you don't have the right things that are in place. NDAs, who knows now, because things are changing with NDAs, but we talk about sales agreements, terms and conditions, etc. So you might be a legal professional in a startup or a growing business, or you were doing litigation. Like I was a litigator, and then I was in charge of dealing with contracts. And that's what it's for. It's not a contract drafting course. You're not going to learn everything substantive. It's going to be when you're dealing with this person and you're going to talk to procurement, this is what you should think about. So I think about what you'd want to have to be able to hit the ground running as you're trying to figure out the acronyms of the company that you represent and all the different kinds of things. So I think that's
great. Yeah, that's great. And we'll come back to this. We want to cut the sales pitch short, but just go check that out if that's interesting to you, if this conversation is helpful to you. We dig deeper into the course. Marcia, as we pivot back to the conversation about IP and MSAs, I do want to root you back to the reps and warranties and the third party. When we're talking about AI, how does that overlap with all this? Because we've got a lot of third party, fourth party, seventh party. We've got a lot of removed. Who even knows the party? It's in the black box. If that changes any of this as we move into the other subjects.
Right. So I spend 2 or 3 hours a day looking at AI issues, partly because I'm in my vast spare time the general counsel of an AI startup. And the world for lawyers and every company is changing dramatically. And your service providers are going to be, because everything is going to be, Microsoft, Copilot, everything is integrating AI things. And as you all know, and by the way, there's a question, I don't want to forget it. Is this course applicable to Canadian lawyers? Generally, yes. The employment documents, less so. But because I did have to deal with, when I was an in-house lawyer, I had to deal with employment issues in 15 countries. So I get that. But as we're dealing with AI, your service providers or your customers are going to be using AI to develop things. And as of this time, it depends on when you're watching this, but as of May 2024, the United States government does not give IP protection to work product that's created with AI. And that's a whole other topic. So you want to be very careful, which you should be thinking about this anyway. You should be asking your vendors, what are you doing from an AI perspective as it relates to doing things with my work? Because you also want to make sure, with the advent of AI has come, it's much easier to have security breaches, et cetera. I've done all kinds of webinars on that as well. So you want to think about that. So we'll go on now to that. So just, I would ask, and, as you're looking at contracts, say, by the way, how are you using AI in my work? If you're the customer, how are you protecting that? And, is that, are you assuming that there's some kind of IP protection for that? Because there may or may not be, depending on where you are in the world and when you were watching this. All right. Indemnification. You guys talked about this a lot. What is it? What's covered? A lot of times people only do indemnification for IP and nothing else. There's a big argument about whether indemnification should only relate to third-party issues or should relate to issues between the parties themselves. And that's for another webinar, which in fact, Mike, there was a great webinar that you guys did on indemnification. So I really recommend you guys watch that one in Law Insider. Defense and control. Cost coverage. So we're going to go through some of these issues when we look at the indemnification clause. Indemnification should be one of the most heavily negotiated parts of your contract. So let's look at a clause. And Alan brings up something important. The ops people almost never look at the agreement. 100% correct, right? That's why I tell people that they should try to write in plain English in case an ops person never wants to look at it. But you should be able to explain this in plain English to them. And when you're drafting and negotiating it, I want you guys to ask your ops people, what's the worst thing that can happen? Who's more likely to screw up on this? If we're receiving the kind of information we're getting, do we have the infrastructure, the IT infrastructure? If you are at a company large enough where you have a CISO, a chief information security officer, what might happen? Well, we have a breach, a cyber attack. Do we have a security incident plan? Because until you know the potential risks, you really can't draft a good indemnification clause, because then you're just cutting and pasting and not thinking about, are you really appropriately allocating and balancing the risks? So go ahead and I think you guys are already starting to type in some of the problems. It's not grammatically correct. Okay.
Man, no contract would pass muster if that was a requirement.
Exactly. All right. So all claims, nonsensical. What does all claims mean? Okay, exactly. What does all claims mean, right? The language all claims related to intellectual property infringement, it's super broad, right? It might require the service provider to indemnify the client against all types of IP claims, regardless of the validity or relevance of the services provided, right? It's not specific enough, which I saw some of you guys said that. Dream on, Jane says, with all claims. I don't know why you guys saying dream on. I have seen this all over the place. This, I guarantee you, there's 435 people. Some of you had this in your contract. You're just being super silent right now. Okay, like, what's wrong with that? All right. It doesn't specify the types of IP. Is it patent, copyright, trademark, trade secrets that are covered, right? Which can lead to disputes about the applicability of it. Okay. There's no limitations or conditions. So it doesn't place any limitations on the indemnity. There's no cap. There's no basket. There's nothing about the conditions. So this can provide the service provider with unlimited financial liability. And there's no procedure for handling any kinds of claims, right? How do you bring a claim? What's a notice requirement? How do you defend? Who controls? So this could lead to all kinds of issues. So Karen, you've asked about a basket. Does that mean that where is the basket, or what is a basket?
Well, I would just point out as an aside, Marcia, Dory shared at 1:45 Central a link to Michael Bloom's webinar about the indemnity. So he definitely digs deep into that, as Marcia mentioned. And so to find that link, that's interesting.
So you have a cap, might be, if I'm the service provider, I will not pay anything over $5 million, right? The basket is, I will not pay anything until the value of the loss is $1 million. So I'll pay between 1 and 5, but I'm not going to pay anything under 1 million. I'm not going to pay anything over 5 million. So a lot of times we see caps, but you don't see baskets. If you're the service provider, again, depending on who you represent, and if you're outside counsel listening and you represent both, this is why you can't just cut and paste from the last contract you did, because your client may or may not want caps and baskets. So again, these are the problems, and I've already gone through these, so I'm not going to do it again. And do you base off contract value? That's a subjective thing. Some people might do it as to 10% of the contract value, Ashley, for the basket or the cap. It depends, and that's kind of more of an internal decision. Indemnification. Let's look at this clause and talk about what we think about it. And I'm being mindful of the time, Mike. First things people like, I like the attorney's fees. I wonder if those are outside counsel. Okay, so we have some David saying it should be limited to final awards. It depends on who you are. Some people are going to want to say, I want it for any accusation of a problem. I want indemnification there. Some people say final adjudicated past the intergalactic court of appeals. That's what I want. So really you have to think about who your client is. And again, indemnification is always a risk allocation issue. Gabriella, she's the gold star. Promptly. I don't like this promptly word. That's why it's in yellow. Okay. Promptly is a word you're going to see in every single contract. I know at least one of my students is on here. The problem I have with promptly is I don't know what that means. And it's really important because I've seen a client have an issue with insurance coverage when their insurance carrier said, oh, well, we're not going to indemnify you because your policy requires you to notify us within 30 days. So if you have an organization that is full of bureaucracy and it's going to take 15 people to get together and make a decision, that 30 days can go really fast. So I would always try to recommend within 30 days, within 20 days, within whatever it is, to make it really clear. Here's another one. And I see, Sean, you've got one of the exclusions we're going to talk about in a minute. Here's another one. What do we think here is a good idea or what's not so good? What does textual mean? Only textual. The scope is too narrow. Excellent. Excellent. You guys are seeing the key issues, right? It's, first of all, this is limited to a specific IP type. It's only limited to copyright infringement and only for textual contact, which could leave out things like trademarks, patents, and could also leave out certain kinds of other things than deliverables. Textual content that leaves out graphics, data sets, software, all kinds of other things that could come along with the deliverables. There's nothing about defense or cost coverage that's mentioned explicitly. So it doesn't say that the service provider is going to defend or cover the costs associated, such as attorney's fees. And that's a significant aspect of full indemnification. And again, the all claims is a little bit difficult. So there's a lot of issues here. The service provider definitely drafted this, says Sharon. It's entirely possible. So again, these are some of the issues that you'll see, right? And when you're thinking about indemnification, it's really important because I spent most of my time as a litigator, and most of these contracts are drafted by people who don't ever go through litigation. First thing when I used to get a matter is I would go to that boilerplate and look at the indemnification. Who's paying for the defense? Who gets to decide on the settlement? Do I just notify them about the settlement, or do they have to decide? What's the cooperation? There's so many different things that come into play. So let's look at this one. Another example of indemnification. Because it's green, we think it's better. Apparently, Mike, they don't think these are better, but we think they're better than the other ones that we came. Karen says only US, right? Accusation. This goes to the comment that I don't remember if it's Sean or whoever else said it should be only, final judgment or something like that. Accusation. Look at all of you guys now pointing at prompt. Every one of your agreements has the word prompt in it because very few people actually put in the days, but the prompt is still there, right? And we didn't draft these, by the way. We didn't make things better. We just pulled other agreements. So lest you think I teach contracts and I drafted these. No, Mike didn't draft them. These are actual contracts that just look better than the other ones, right? So the accusation, this is the part that's important because depending on who you represent, you're either going to want to be the accusation or a claim or an allegation, or you're going to want it to be a final judgment. You have to have those conversations. And prompt is better than immediate for some people. Immediate people generally know. Prompt could be 2 weeks from now, and that could be an issue. So what are some things we want to think about? You have to have a clear scope. What's covered and defense and control. Does the indemnifying party have the duty to defend the indemnified party, control the defense, settlement decisions, cost coverage? Everything's got to be included. Reasonable attorney's fees, settlements, court costs, because remember, fees and costs are not the same. Notification. How do you notify them of a claim? And what's the cooperation? You have to detail the cooperation that's expected from the indemnified party because they've got to provide the right assistance. Contributory infringement, exactly. Because we're getting to the next slide. Look at you guys. Intentional misconduct and negligence. Is it negligence? Is it gross negligence? These are some common exclusions. Modifications, I saw that earlier in the chat. What happens if you're modifying it away from the intended use? Okay, using beyond the scope. Again, the cap and the liability. Make it really clear what triggers the indemnification. We've also got a situation where we're looking at the duration of the coverage. How long is this? And is there a duty to cure? Is there a right to cure or is there a duty to cure? Those might be two different things. And I don't know if I'm pronouncing your name right, Ramey. Okay. And Carol says she wants this to be the settlement to be conducted reasonably and in good faith. We all want that, but who knows? Okay. So let's look at this next one. Confidentiality. We're running short on time. This we generally know, so I'm not going to spend a lot of time on this. But let's see. Remember, confidentiality, you might have an existing NDA, right? But your existing NDA might not be strong enough. Or you might think we need a separate document, but confidentiality is not always assumed when you're dealing with these. So you want to have robust confidentiality, especially for an MSA. What's wrong with this one? Or do you like it? Right. You've got to have your definition of confidential information. And by the way, you can't say confidential information is what we say is confidential, right? It's a circular definition. I see this all the time, right? So you've got a vague definition of confidential information, doesn't have any specificity. And this is something that also you need to have in your MSAs. How do you handle this confidential information? How do you store it? How do you handle it? How do you destroy it? What happens after the agreement's done, right? There's no consequences for breach here, right? It doesn't have anything about what is that there's a breach, which means there's no deterrence. It doesn't have anything about the third-party disclosures, okay? It doesn't address subcontractors and third parties because those are often the people that are going to leak the information, right? The required by law thing, I see somebody else having this here. If you're going to have something about required by law, you have to make sure that the other party has the right to be notified this before you disclose, because that party that is the person that you might have to disclose their information might need time to talk to the lawyers to get a protective order or something like that. So even if it's legally compelled, you still want to have something that talks about notice and how that's going to be handled. And Karen says, I prefer this clause to be mutual, right? So again, because you guys are going to get the slides, this is a little bit of what I talked about. And of course, you're going to have the permitted disclosures. You're going to have the typical carve-outs that you have in there. You already knew it, etc. And the return of information is very, very important, right? Because here's a problem that we might have. We may have a problem that, how do you destroy the electronic information? What if it's on a hard drive? What if you have printouts of stuff and it's an Iron Mountain in some warehouse? How do you deal with all those kinds of issues? This one is better. And somebody talks about oral disclosures. Keep in mind that some courts are going to look very differently, and some courts are going to say, we don't care if you called it confidential or not. Based on X, we think this is confidential, or we don't think it's confidential. Exactly. The post-termination periods as well. We're going to have some of that in a minute. So as you're looking at this, how comfortable are you guys about this? Right? Sending it to the, what's the degree of care? Now, by the way, be really careful about the degree of care, because if your service provider has a schlocky, terrible degree of care, then as good as they, think that's why industry standards important. I mean, if you're in a specific industry, maybe you guys use NIST or some other framework. If there's a framework that you absolutely want them to use for confidential information, you want to put that in there, because reasonableness is in the eye of the beholder. Okay, how practical is it to have individuals sign? It might be a very small company, but if it's a very big company, probably not. So you really want to think about what's the standard. Now, again, the marking standard for confidential information is really going to depend on your courts. We're not going to talk about this here, but that's why even the choice of law you use is going to be really important. Okay, so what are some best practices? Make sure you have some employee training and policies on the specific MSA. Think about whether you need some NDAs for the employees and subcontractors who may access confidential information. Again, audits, and then think about the technological safeguards. I'm a former chief privacy officer, and I still think about these things, right? Do you have, if there's a breach of the confidential information, by however it happens, right? What are the technical safeguards that you have in there? What are the security protocols you have? Are you using secure platforms to share information? Do you have a clear response plan? Are you using encryption? Or are you guys sending things via WhatsApp? What are the access controls you guys have in place? Okay, so all of those are really, really important things to think about. Allison says the number of people who email docs with tax ID numbers, right? So some of you guys should have a secure platform that's not just your email, but that's a center or a secure platform where you actually trade information back and forth. And you, of course, want to think about the duration and those kinds of issues. Now, I know we are short on time. Mike, I know that you're going to want to say some things. And I'm going to check in the Q&A really quickly to see if there's anything we can add. But Mike and I are going to go through the Q&A afterwards, and we're going to put together answers. So when he sends out the slides, we'll answer the questions in the Q&A that we couldn't. And we'll also look through the chat as well so that we can get some of that as well.
That's great, Marcia. I'm going to ask you to advance one more slide, I think. Yeah, just in closing, I just want to say thank you to Marcia. And And again, one of the reasons we love having Marcia around is because she provides that sort of practical view, but also with the heart of a teacher, right? The ability to do what she does to teach people how to really use these skills. Marcia, I want to ask you again to kind of echo a little bit how this transfers, the kind of stuff we're talking about here, transfers to that course to turn that sort of competence into confidence in these new roles. What would you say to people who are considering this course, for who it's for and who it's not for?
Right. So first of all, I get no commission. So if 100 people buy it or nobody buys it, I don't get any more money. So I'm not doing this because of that. I'm doing this because I remember what it was like when I was a big law lawyer, where everybody comes to me because they need help. And then I went in-house and people are like, well, do we really have to do that? And you don't understand our business. And we're never going to sign that, or the customer's never going to go for that. And so if you know, you've got to learn, you've got to know the law, that's baseline, but you have to understand the business. So when we go through the course, we talk about, here's what's going to happen if you put this in. Here's when do you want to have a super cap? Because we talked about caps and baskets. Some of you guys may have not have heard the concept of super cap. We talk about things about, yes, you might have a terms of use and privacy policies, but what does that really mean? How do you look at your NDAs and what's going to be enforceable, what's not going to be enforceable? And especially on the employment issues, because everybody's got employees. One of the biggest things I talk about there is dealing with independent contractors, especially if you're a smaller company. But I was at a company with 26,000 people and we still had issues with independent contractors. And so we talk about, how do you make sure, my goal is that you guys are saving your company money. If you are in-house, you know for a fact you are not a revenue generator, you are a cost center. So I want you to be valuable and also know how to ask the right questions, know how to ask the right questions to your in-house counsel, know how to ask the right questions to your internal stakeholders, that you have a baseline. Hey, we've got this in our sales agreement. Have we thought about X, Y, and Z? And so we go through the contracts and we go through clauses and we talk about things. I say, ask your operations people this. Talk to your HR person about that. Ask your IT person about this. So you should be able to sit there with your contracts and or a list and be able to go and ask intelligent questions. And that's really where you add the value. So I think I would leave it at that.
That's great. Well, we're at time. Dory, I'm going to ask you to just real quick put the link and the discount code back into the chat, and we will leave you to it. We will, as Marcia mentioned, gather all those questions. If you have a second, put another question in there real quick. We'll take that from the Q&A. Thank you again, Marcia. We'll see you all in the next learning opportunity. Y'all have a great day.
Thank you all. Take care. Bye-bye.